Good morning. My name is Marcy Siegel. I'm a senior family lawyer. I was called to the bar in 1990 and I practiced criminal law for 20 years and decided to transition. And now I'm in my 14th year as a family lawyer and I've never looked back. The majority of my work is high conflict. I suppose it's because of my criminal background, partly that I have the muster to be able to handle extremely high conflict situations. When people come to me, it's because their family law matter, if it's in court or not in court, is in complete disarray. The parties are so far apart that they cannot settle anything, and sometimes criminal charges are laid. My role is to look at the case, try to see how to settle it, try to get it to the end sooner than later, and to obtain a fair result. One of my expertise is in financial disclosure. So understanding that family law and the documents that you're supposed to file in court are really supposed to be and are simplified. So if you're in a common law relationship or you're married, you will be obliged to fill out, at least for court, either a Form 13 financial statement if you're common law, or a Form 13.1 financial statement if you're married. The documents are available online, and basically it's a financial dump, literally. Uh, you fill out what your expenses are, what your income was the last year, all of your bank account statements, your assets, any other holdings anywhere in the world, um, and your liabilities, be it your mortgage, line of credit, monies owed um, to other sources or monies owed to you. And then once both parties provide their financial statement, the next step would be to provide each other with a net family property statement, which is basically comparing um, one party claims they're owed money, the other party claims they're owed money. And as the process progresses in court, you sort of narrow it down. So by the time you're before trial, you have to fill out a comparative net family property statement. Again, these forms are online where it gives a comparison what each side believes the other part that the other side owes. And it's not just the number at the end, it's the parties' perceptions as to the value of the assets or the liabilities. Let me go back for a minute. Let's say you're getting married, and neither of you want to disclose your financial holdings. It's not ideal, but it's not 100% necessary that both of you fill out a financial statement prior to entering into a marriage contract. But you have to appreciate as follows. Um, when you're married, when you just get married, everybody's happy, right? And they don't want to look like they're being selfish or penny pinching. So you don't enter into a marriage contract. And then when you separate, lo and behold, there's an argument about date of marriage deductions or what you had on date of marriage. So it is preferable that you always fill out a financial statement for any contract, be it a prenuptial agreement, marriage contract. In terms of a separation agreement, unless you don't own property, you've been married for maybe a few years, neither of you has any assets or minimal assets, that may not be necessary. But for everyone else, it is necessary. So, unfortunately, there are many tricks to the trade that some litigants and some lawyers will, not all, but some, will try to decrease any equalization payment that's owing to the opposite party. For instance, I'll give you an example. If you have an RSP, your date of separation, the value is $100,000. Okay. The lawyers will usually try to deduct between 15 to 25%, which is a notional cost amount if you were to sell or withdraw from your RSP, even though you're not. The value of assets on date of marriage There will be differing opinions. So unfortunately, that it can become very high conflict in the financial area. So I'm just going to give you like a hypothetical and or sort of based partly on facts. So when parties separate, they should provide their financial statements within a short period of time. I would think within 60 days. That can be considered a long period of time, but there can often be delay. Once the financial statement is obtained, you then have to get copies of each bank statement at date of separation and date of marriage, if you have that. And you provide a screenshot as part of your disclosure because it doesn't matter what you put in your financial statement and the fact that it's sworn. It doesn't mean that the figures are accurate. So you need the underlying bank statements to prove what your balance was on the date of separation. So if you're getting married and you have date of marriage deductions, I would get copies of those bank statements as soon as possible because the bank only holds them for 7 years. And I have some clients after 20 years, they don't have the bank statements anymore. So they lose the date of marriage deduction. Because how is a judge to decide if your oral evidence as to what you had on date of marriage is actually real? They can't. So you need these documents. You need the bank statements to prove. Okay. And that's one sort of game in trying to obtain these statements and the delay in obtaining the statements. So that's sort of one trick. And it's really important that regardless of how the other side is acting, that you provide full financial disclosure and timely. The courts look at not providing financial disclosure as the cancer to family law. Those are not my words. It's actually what a judge has mentioned and other judges have relied upon. So I provide full financial disclosure. That's what I do. Now, obviously, what the client tells me he or she has, I have to go on what they tell me. I don't get authorizations to go to every bank and see if they have bank statements. So there has to be a trust relationship between the client and the lawyer. Um, I don't play around. I don't hold things back. I provide the full financial disclosure. If the other side is not going to provide it, then I bring a motion and I bring a motion for financial disclosure. And the courts take the view unanimously that delaying providing financial disclosure upsets the parties, upsets the system, is an insult to the system as it is, and it's contrary to all principles in family law. So you will find that if you don't provide financial disclosure and you're in court, the other side is probably going to bring a motion to strike your pleadings, which means that they're going to bring a motion that you cannot proceed any further in litigation, that you have no say, that you can't serve any more documents, and they may try to get an uncontested trial. So that's number one. What is financial disclosure? First of all, if you're going to go to court, you need your last 3 years of your notices of assessment in order to file your pleadings, including the financial statement. So that's the first part that you have to give. Second of all, your financial statement, which details the balance of any of your holdings or debts as of date of marriage, date of separation, and today's date. And then you have to provide the screenshots. And and then that's part of what's called the certificate of financial disclosure. So that's the first step. And even if you're not going to court, you should be providing that to the other side. The next step would be, and quite frankly, you should provide it originally, is your last 3 years income tax returns, not summaries, but full income tax returns. The other side is entitled to that. You're entitled to the same information because financial statements, your income tax returns will show any investment income you made money or lost money, your employment income. And if you're self-employed, it's a T2 income tax return. So that should be gathered first and foremost without the lawyer even asking you to do so. Okay. So let me explain now common law. In a common law marriage, the court assumes that you made a conscientious decision that you didn't want to merge your finances when you started living together. So therefore, what one person has on date of separation, what the other person has on date of separation is theirs. There's no equalization in common law relationships. As a general principle, you can ask for spousal support, child support in a common law relationship. But if you're going to ask for, it wouldn't be called equalization, but let's say the two of you lived in a house and he had the house in his name and he claims he solely contributed to the house. Then on date of separation, he's going to take the position that one, he's solely on title. Two, you two weren't married, so you're not entitled to any of the property. This is a real misconception for many people because they don't understand. If you're married, upon separation, with some exceptions, and I'll explain in a minute, you're entitled to equalization of all net family properties. So that's the difference, plus spousal support, child support, if it's applicable. So that's the real difference. It's assumed that if you two get married, you want to merge your finances and you want to be partners in life as well as in financials. So let's now go to the common law. So let's say, for example, I'm living in a house with my partner. It's under his name. I'm staying home and taking care of the house and taking care of the children while he is out working and he's solely paying. I am doing the renovations. I am doing upgrades to the house. Because I'm running the house, it couldn't function without him. I would want to bring what's called a trust claim. So, in other words, I'm asking for the court to make an order that I receive essentially some of the equity in that house because of the contributions I made during the marriage. Now, obviously, if you made financial contributions, that increases the strength of your claim. If your contribution was as a stay-at-home parent that was taking care of the home, it won't be as strong of an argument, notwithstanding that staying home is an equally important role as it is for the person that's working. But put that issue aside for another day. It is much more difficult to argue that for a trust claim that essentially he's holding the property in trust for both of you, that you receive part of the equity in that home. But there's always exceptions to the rules, and that's why the law allows a common law spouse who feels aggrieved, who feels that it would be unfair for them not to share in the equity in a home or in a business. They can bring that motion to court as part of their application. However, it's your onus, it's your burden. So you better bring it. In other words, you better have the documentation to prove that, in fact, you contributed to the house. Now, you wouldn't have to go to court if you didn't want to, and you could try to resolve it with the lawyers. You could still make that same argument when you're negotiating a separation agreement. Okay, so, but you don't split your bank accounts if you're common law. Now, obviously, if you enter into an agreement where the two of you will share, then that stands. Now let's talk about marriage. So in when you two marry, it's assumed that you two want to be partners in every way. Okay. So when you separate, uh, with some exceptions, you basically split your debts and your assets and you equalize them. So I'm going to give you an example. So in your financial statement, you would put down there, if let's say you had $100,000 in your bank account prior to marriage. Okay. So you would put that on your date of marriage deductions. So you get a deduction of $100,000 from whatever equalization payment you would have to pay. It doesn't work like that. It gets configured with DivorceMate and they shoot out a number. So whatever you come in the marriage with is deducted, same as debts. Okay. So let's say you marry for only a couple of years. The law is that if you're married for 5 years and under, you can bring what's called an unequal equalization claim or a variation of share claim. Because it would be unfair to split 50-50 for a short marriage. Now, if you get past the part where everybody's disclosed their financials, then great. You can then move on to the next part, which is figuring out the equalization payment and whether or not there should be a variation of share. In the old days, they would basically look at it like if you were married for 1 year, you'd get 20, you'd get a percentage of it. Okay, so you'd get 10%. It doesn't work like that. The court looks at all of the factors in deciding what's fair and whether or not it should be 50-50 or not. Whatever's in your name at date of separation is yours. So for instance, if you own a house that's solely in your name, except for the matrimonial home, what you do is you pay 50% of the value on date of separation. The other party cannot ask you to sell the property, except there are exceptions. Again, if you're holding the property in trust for both of you, and the other side can show to the court that, let's say it's me, that I've done so, then the court can order that the house be sold. But it's rare that that would happen. A matrimonial home is a whole different kettle of fish. As a general principle, when the matter is resolved or when the property is sold or when the buyout is done, that's the value of the matrimonial home, not on date of separation. Okay, so that's why some spouses will stay in the house a lot longer than they should, not only to try to negotiate a more favorable settlement, but to not have to pay the carrying costs and make the other party pay the carrying costs if that's the case. So those are the basic differences between common law and being married. So I have been involved in many, many high conflict, financial, complicated cases. And here's the bottom line. You will never be able to find out what monies are being hidden. There is no way to hire a private detective, to have the private detective find out what bank accounts your ex-spouse owns, and then use that in court, because they're not really allowed to find that information out. So that's problem number one. Problem number two, it's extremely difficult, if not impossible, to find out if there's money being hidden in the Cayman Islands. Okay. So it's rare you're ever going to find out how much money the other person is hiding, if they are. Okay. So attention should be placed on obtaining copies of all bank statements all over the world. And if there's going to be resistance from the other side, then have yourself or your lawyer write an authorization and direction to have the other party sign that you yourself can go to the bank to find out how many accounts that person has and what the value it is. Obviously, it shouldn't be up to you to do so, but that's one way to deal with it. The internet is an amazing place to investigate what your spouse, your common law, your married spouse is doing or not doing, what companies they own, what businesses they may be involved in, what they're presenting themselves to be. I had a client who, in order to get more clients, put on her LinkedIn that she built up a $5 million company, which, was sort of stretching her success, at which point the other party found that and then decided to amend their pleadings to claim spousal support when they're not entitled to spousal support. So, you've got to be really careful what you say on the internet. You've got to be really careful what you write, text, email to the other side. It it could come back to haunt you. So make sure that there's not any ammunition for the other side. Okay. Number two, property searches. Now, part of the problem is, excuse me, it's a good commercial. Part of the problem is that you can't do like a full-blown property search for all of Ontario. You have to do it for each area, so it could become expensive, but it's worth every penny. And so you need to do the property searches. You can figure out in Ontario. I mean, there's York Region, Toronto, Peel Region. Then there's the outskirts of Milton. It's worth every penny. Find out if that person actually has a property. Number two, there's an online search system that you can find out if somebody owns a company. Now, it's not so easy if you don't know the company name and if the person isn't using their name directly. But when you do the search of the person on LinkedIn, or if you have the document, if you have the Ontario number or the Canadian number, or you have the company name, you do a corporate search. Beyond that, you can then do a corporate profile search. So, for example, I had a case recently where the other side had said that the company has not been operable for 5 years. And then I did a corporate search and a profile search and found out that the person just filed their tax returns last year. So on these T2 income tax returns, you have to actually put on there whether or not this is your last year of filing. So these are invaluable, okay, because the other side will inevitably say, I'm not making any money or nothing's happened. So that is key to do those searches. And again, we're talking about what I've just told you about $750 or $1,000 in total. Obviously, if you don't own property, it doesn't make any sense. Okay. But these are some of the tricks of the trade. Now, people will sometimes put bank accounts in somebody else's name. And so when you want to ask for disclosure, you want to make sure that you ask for all bank accounts in their name, joint names, held in trust for them, anywhere in the world. Okay. And that way you catch if the bank account is held in his mother's name, who I had a client do that too, that claimed it was his mother's account and didn't disclose it, and then finally disclosed it was in both other names. And that is disclosable and you must provide it. However, what the person then did was they then just closed the account. But the courts see that. Okay. Part of financial disclosure is necessary to determine spousal support and or child support. Okay. And that is something that if you're self-employed, it's difficult to determine your income unless you're a very small business. And I mean, one or two people. You need a valuation of your income for support purposes. Let me explain. Let's say I own my own company. I made $100,000 revenue. Okay, but I decided to deduct $10,000 that for, let's say I had a car lease. Let's say it's 800 a month. Okay. So that's about 9,600, $10,000 a year. So I deduct that from my income tax, which means I take 100, I minus the 10,000, it equals 90,000. Okay. And then I only pay tax on the 90,000. That's for CRA. And either they don't care or they don't have the time to deal with it because nobody uses their car 100% of the time unless you're a trucker and you're writing off that vehicle. But otherwise, nobody's doing that. Okay. It would be impossible. So in family law, you would have a valuator look at your expenses, speak to you, and let's say for the sake of argument, they would reduce it to $7,000 per year so that you can only deduct 70% of the car use. Okay. That $7,000 goes back. So it's now $97,000, but you also save tax from on that 10,000. So that's probably another 1,000. So it's now almost gone back to 98,000. So, I mean, if you do the math, you understand. So sometimes litigants will try and write off as much as they can to reduce their income for CRA tax and for spousal support or child support purposes. So what a valuator does is they look at your income tax returns. They should look at your bank statements if you're self-employed, because you don't always report your income. They'll look at your financial statements, your ledger statements, and then they will add back any of the expenses that you shouldn't have been able to write off. And then they'll come up with a calculation as to what your income is. So you can imagine the dueling experts. The benefit of having that report is that a trial judge is not going to do the calculations themselves. The trial judges rely on experts to assist them in certain areas. So valuating of income, that has a lot of power, those reports. So with dueling reports, a judge is going to have to make a decision which report to favor or just split it down the middle, which is what they'll sometimes do in the appropriate circumstances. So don't assume that with the NOA of a self-employed individual, that's their income for support. It isn't. Okay, now let's talk about businesses. So on date of separation, if you have a business, if you have stocks in or private shares, okay, you need to value that as well. And obviously it depends. If it's a very small business, then you may not need to valuate it. But otherwise, you're entitled to 50% of the value of your ex-spouse's business on date of separation. So again, it's necessary to provide financial disclosure in order to do that. And valuators aren't cheap. Obviously, the more in-depth the analysis is, the more expensive it will become. But again, you have to weigh and figure out if it's worth it to hire. If you have a business that couldn't be worth more than I don't know, $10,000, it doesn't make sense to spend $10,000 for a valuator. So in family law, whether you like it or not, you always have to be sort of assessing and balancing if it's worth financially to go that route. Okay, so that's something you got to think about. So you've got the businesses, you've got the income. So for spousal support purposes, both parties will have to have their income valuated unless they're an employee and you use a T4. You also want to find out if they're obtaining any benefits if they're an employee, because that gets added into their income as well. It seems complicated. It actually isn't complicated. It's not complicated if you actually provide the financial information that you're obliged to do. The Divorce Act makes it clear what you have to provide, especially for child support. And as I said, if you delay providing this information, and especially in court, the court is not going to be happy. And the court is going to start making orders against you. Okay. So just to recap, number one, when you are getting separated, you want to gather your financial information as quickly as possible, printouts of your bank statements, printouts of your mortgage, line of credits, and your investments. Print that out. Bank statements include investments, GICs, RSPs, TFSA. I've been involved in cases where they've claimed that TFSA isn't really a bank statement. Of course, it's a bank statement. And there's always excuses that are going to be made as to why disclosure hasn't been provided. And the first thing they'll do is deflect. So that's why I provide the disclosure as quickly as I can. Number one, it shuts down any of the noise on the other side. Number two, it's because you're obliged to do so. And family law litigation is incredibly stressful. And it rocks the parties to their core, especially when it comes to financial situations. Okay. Let me give you some other some other information. You have a pension. You have a pension, you're a teacher, you're with a union. Amazingly, you contact your pension administrator. They do the date of separation analysis of what you're going to have to pay your ex uh, by way of half of the pension. So you don't even have to hire anyone. They will do that. It takes about 60 days. So I would, when you separate, I would not waste time on that either to determine what the pension is. Now, obviously, there's ways to deal with the pension because the only way you can get half of it is to roll it into what's a lira, or if you have your own RSP account. You don't get the money. Okay. So it gets split at source and it goes to you in your lira account, and then you get to deduct from it when you're entitled to. So you should be doing that as well. Household goods, that becomes another problem. So in a case that I did, the my client remained in the house. The spouse was out of the house, and when the property was sold, neither party really wanted the goods, and there became a tug of war as to who was going to take the goods. Because in your financial statement, you have to put the value of the household goods. In that case, we actually used an appraiser. There's actually appraisers out there. They usually deal with very expensive valuables or antiques. But this appraiser actually went into the house and valued the household goods. And that was used as well in court to determine what each person owed in equalization. Valuables. I find that more often than not, when people provide their financial statements originally, they do not include these numbers. And it's really important from the get-go to go on the other side and ask them to value those assets. Because next thing you know, you're at a settlement conference, nobody's bothered to deal with it. And a judge may say, just leave it. Who cares how much the jewelry was? So you want to get onto that early and you want the proof. So obviously for jewelry, you'd have it appraised. Okay. Um, so you want to make sure that that section is filled out in its entirety. Again, if you have any valuables at date of marriage, you have receipts, you have appraisals, especially jewelry, make sure you keep that documentation to use, because again, the other side at separation may say that there's no proof of that. And then that becomes another few $1,000s between the lawyers to figure that out. Buyouts of matrimonial homes. The law says that if you two cannot work out the value of a property by way of a buyout, it gets sold. A court is not going to take the time to determine really what the value of your house is. That's not their role. In fact, the truth is, you shouldn't be resolving your matters in court. You should be resolving matters between each other with collaborative law, mediation, or between lawyers drafting a separation agreement. You know, why would anybody want a stranger, even though these jurors are very accomplished, work very hard, and really uh, respect their work and the impact it has on parties? They don't want to be the ones determining decision making or a parenting schedule or how much one owes the other. They don't, because parties, it's their lives, but they will, and they do, and they work very hard. And as we all know, there will never be enough family court judges for the type of litigation that some litigates want. So it's never going to happen. And here's the analogy I give. If there's 100 judges that are appointed in Ontario, 75 will be reserved for criminal. 15, now I'm making up these numbers, okay? It could be a little less or more. 15 for family and 10 for civil. So in criminal, you have all the time in the world, subject to a judge cutting you off if they have to. It's oral evidence. There are documents, but it's mostly testimony. Okay, so there's a lot of patience there. In family court, if you're going to bring a short motion, and a short motion would be for financial disclosure, child support, spousal support, exclusive possession of the matrimonial home, you get it's 59 minutes, or in certain jurisdictions, 1 hour. That's it. So each side gets, let's say, for the sake of argument, 25 minutes each because you want some time for the judge. That's what you got. You really got 5 minutes. It's by affidavits. Usually it's 12 pages, double space with 10 pages of exhibits. So there's the ability to put in more under certain circumstances, or some lawyers do so anyway. And you got a judge for less than an hour. Okay. So you're not going to have all the time in the world to tell your entire story. And quite frankly, the court wants to focus on moving forward as opposed to dwelling in the past. Okay. Obviously, if there's allegations of domestic abuse, that's important to recognize. If there's alienation of children, the courts have all the time in the world. But the courts expect that you're going to wrap in a bow your financial statements, your net family property statements, and your comparative net family property statements. And they want it fast, and they want it clear. Okay. And that's your job, to spoon feed the judge, to show the judge what you're entitled to or what the other side is not entitled to. Okay. So you always need to make sure that you are fully organized at the beginning, that you've presented everything, um, and that it's done in a coherent manner for a judge to understand. So if you're going to involve the courts, please understand that there is just not enough time for these judges. I want you to imagine something, and no, I'm not doing this for the judges. I don't have any connections to judges other than appearing before them. But imagine that they have to read all of these affidavits that talk about horrific allegations, mostly false, I bet. And they have to synthesize all of that day in and day out. It's difficult. It's difficult for the clients, and it's difficult for the lawyers. And in some ways, it's purposeful to increase the conflict. Our job as lawyers is to decrease the conflict as much as possible, and to tone down any of the egregious allegations, especially regarding the children. Lastly, I just want to talk about child support. There appears to be some misconceptions about child support. Number one, child support is for the child, but it goes to the parent. So if those litigants want to pay the children themselves because they're trying to cut off their nose to spite their face, it won't count. You have to pay the parent. So that's number one. Number two, you have to make sure that you're providing full information to your spouse, your ex-spouse, to determine the appropriate amount of child support. And the longer you wait without giving anything, the worse you're going to look in court. I think post-COVID, I think everyone got a shake, and we all realized that life is too short, and spending our money on high conflict litigation and on trying to deprive the other spouse of peace is not working. The courts see it. The courts see it every day. They're not stupid. They will be able to sniff out in a heartbeat if you're not providing full financial disclosure. Okay. I remember a case I did where the individual waited 5 years, 5 years after separation to actually give their income tax returns from the previous 5 years. So that spouse, ex-spouse, waited for 5 years to even really know the actual income based on the tax returns. What also happened was that the ex-spouse didn't want to disclose their true income and their true future income. So representations were made as to their future income that was significantly less than what it really was. And unfortunately, that only took years later to find out. So for those that think they're going to be able to get away with it, okay, they won't. because bank statements are held for 7 years. And obviously, you don't want to wait 8 or 9 years, but you will be discovered. So, in closing, I want to first of all thank you for all being here and listening. I hope I've given you information that is helpful. To me, knowledge is power. And without knowing your rights and what the court will do and what your obligations are, your head will be spinning all the time. Once you know the roadmap and it's no longer an unknown, you'll be able to navigate this process better. Not every client needs to pay a senior lawyer. There are many times I turn cases away and refer them to more junior lawyers or express to them that they don't need to be paying my fees. I'm not going to do a collaborative separation agreement based on my current rate because it's just not worth it for the client. If there's not much involved in terms of financial assets, then it doesn't make sense. Having said that, obviously, I want to give value. So I believe that I give value to every one of my cases. I care about every one of my cases. Um, I'm not, I'm not the softest. I'm certainly not the softest, but I'm going to assume the following. Between holding your hand and saving you money and getting results, I think you want the saving of the money and getting results. And it's not that I want to be tough. It's just that this is, you are entrusting me to help you. That's a very daunting task. I don't know if I could trust anyone to do that. But if you're asking me to help you move forward with children, with your financial situation, then it's incumbent on me to do 100%, 110%, 110% of the time. Now, I'm imperfect, and at any given time during the day, there's 15, 20 calls coming, um, and you're getting nonstop emails. Sometimes it's a battle zone. It shouldn't be, but sometimes it is. So understand that if you look at the big picture, the key is to simplify the process as much as you can and not complicate it. And hire a competent, good family lawyer to assist you. And what I do with a lot of my clients too is I have them involved. So, in fact, they will draft some of the narrative. They will be involved in preparing the financial statement. I look it over, of course. The more money they can save, the better it is. Anyway, any questions, please feel free to reach out. And thank you for taking the time to be with me today. Have a great day. Bye bye.